Federal government agencies will have a little bit less power thanks to a new ruling from the U.S. Supreme Court. But will this be a good thing for Americans?
For the past 40 years where Chevron doctrine was in place, things have just spiraled out of control a bit, where when a federal agency appears to do something inappropriate, there was just almost no option to rein them in.
On this episode, we review the Supreme Court's Chevron decision, which puts the responsibility back on Congress to pass clearer and more specific laws. You're listening to Defending Ideas. Defending Ideas is a weekly podcast produced by Sutherland Institute. On this show, we are committed to renewing the principles of common sense conservatism, making you a better champion of sound ideas. Welcome back to another episode of Defending Ideas. I'm your host, Nic Dunn, and this week we're talking about the U.S. Supreme Court. As is customary in the month of June, they often hand out rulings, decisions on various issues that affect the lives of Americans and, of course, those of us right here in Utah. And we want to go over some of the high points of the court's term and also dive into one particular case, which is being called the Chevron doctrine or Chevron deference. Might have heard of it in the news. I'm going to explain what that is and why it matters on this episode of Defending Ideas. But I'm really excited to welcome into the discussion Kelsey Dallas. She's a reporter for Deseret News, where she covers the Supreme Court, religion, and sports. Kelsey, welcome to Defending Ideas.
Thank you for having me.
It's good to have you here to help add some really important context to these issues. And in conjunction with that, we'll get some really good constitutional insights from Bill Duncan. He's, of course, our constitutional law and religious freedom fellow here at Sutherland Institute. Bill, thanks for coming back to the show.
Thanks for having me.
So I want to kick things off, Kelsey, starting with you. Our folks out there are going to hear and see a lot of news coverage about the Supreme Court. Of course, these things kind of trickle out throughout the year, but then there's a lot of cases that are released in June. And for most folks who just see a headline here and there, or maybe read an article here or there, and may not know what are the most important things they should be paying attention to that come down from the Supreme Court. So I want to start off by asking you, as you've covered the court and looked at this term in particular, what would you say are kind of the most important cases? Maybe not all of the most important ones, but what are some of the highlights of the court from this term that you think folks out there need to be aware of?
There were so many cases this term that were worth following, although I certainly understand that most average Americans aren't looking to read Supreme Court stories every single day. But the ones that I would call folks' attention to had to do with former President Donald Trump, with access to abortions, and with gun policy. So with President Trump, he had been asking first about whether he could be on 2024 ballots. That was very quickly handled. I believe at the beginning of March, the Supreme Court ruled on it and said that states do need to keep Trump on the ballot. The other case has to do with the scope of presidential immunity, and it relates to former President Trump's alleged involvement in efforts to overturn the 2020 election. The abortion cases were notable because we're now 2 years out from a decision that overturned Roe v. Wade. And so we're continuing to grapple across the country with what abortion policy looks like now. There was a case about the FDA's regulations of an abortion-inducing pill called mifepristone. They ruled on that in early June and said that it could remain available across the country, at least in states where abortion is not banned or banned in most circumstances. They also had a case about Idaho's abortion policy and what to do when a state-level abortion restriction seems to come in conflict with a federal law protecting emergency access to abortion. That was an interesting situation where the court didn't answer the full question. That is a very much still a live case, and it's just that in the meantime, there's going to be access to emergency abortions in Idaho. And then there are the cases about guns that had to do with whether someone who's under a domestic violence restraining order could access a gun. And the court said that it's okay to keep them from having a gun, and that doesn't violate the Second Amendment. And then they were answering a question about whether bump stocks that change a semi-automatic weapon into a weapon that can fire more quickly, does that constitute a machine gun under a 1980s law, and they said, no, that's not an appropriate use of that law. And so many of the rulings were joined together by this question of whether the federal government had been pushing too far in the rules and laws it was putting in place. And the Supreme Court was trying to rein in that sort of administrative action.
Kelsey, that's a great overview, and hearing that, I'm thinking there's a lot of juicy issues that the court deals with, which is why I think it's been one of the most interesting things to follow. And so I'll encourage folks to go follow your reporting. We'll link to your work in the show notes for this episode, because I think you do a good job of breaking down some of these issues in terms that, again, just regular folks can understand, which is so crucial. But you mentioned something right there at the end of this question that maybe is implicit in a lot of these cases of whether the federal government has gone too far in a lot of these areas, sort of their federal authority, the administration. What's your sense as you followed these issues and in your reporting and in folks that you've talked to who are sort of in and around these issues? Is that kind of broadly agreed upon that, yeah, this term, if there was a theme from this term, it was sort of about whether and in which instances the federal government was exceeding its authority, especially the executive branch. Is that right? Is that the right encapsulation for these cases based on who you've talked with in your reporting?
That's been the theme, not just this term, but several recent terms. And that's because Congress has been locked up for so long, like barely passing anything that really moves the needle on some of these major issues. And so in the absence of action on something like gun control, the federal or the presidential branch is saying, okay, well, if the Congress can't pass a law, we're going to do what we can to give federal guidance on this issue. Or how do we look back in past decisions and justify some new rule along an issue that we care quite a bit about? So it feels like it's not new for them to say the executive branch is going too far, but it certainly stuck out to me that there were several rulings in the past few weeks where the answer is Congress needs to do something about this if something is to be done about this.
Bill, I want to get your thoughts on this because I think what Kelsey said is really interesting and important because based on this, it seems like the Supreme Court's decisions are really less about the Supreme Court itself and more about other branches of government. In this case, as Kelsey is alluding to, if Congress isn't doing its job, and so the executive, the president, his administration, feels like they need to step up and sort of extend themselves in terms of their power to make a difference, and then that leads to the Supreme Court reining them back in, is that a good, again, overly simplistic summary of what's going on? Is that sort of the diagnosis of our woes at the federal level?
I think that's right. I thought Kelsey's description is very accurate. I mean, we do see that happening. A couple of years ago, over a couple of terms, we saw a similar kind of thing happening with religious freedom. There's a lot of court cases and sort of setting out what, some of the boundaries for what states and federal government can do. And I think we are seeing something similar in terms of the roles of the branches. At its best, the Supreme Court is supposed to be protecting the integrity of written law, the Constitution, obviously, but also the statutes that they're, tasked by the Constitution with interpreting and applying in certain situations. So, I think it's right for the court to spend their time setting out kind of what can what ought the other branches to do, what can they do. Again, they're not doing that because they're interested in their own, I think, authority. Typically, they're interested in ensuring that the constitutional parameters are being respected by different branches. And so there is one case where the Supreme Court's own authority and that of the other federal courts became really important. And you mentioned at the very beginning this case involving what they call Chevron deference, but it fits really well with what Kelsey's describing, that the court needs to clarify exactly what the role of administrative agencies is, what they can do, what they can't do, and then in this case how the courts interact with those regulations, and I think Kelsey's exactly right, because in some ways Congress has sort of stepped back into an oversight role, and a lot of times when you watch the news and you hear hearings from Congress, what they're talking about is why aren't we regulating this, or why are you regulating it that way? And I think to framers that might have been a little strange. I think if they were watching this, they'd say, "Wow, why are you spending so much time overseeing what the legislative branch? What the executive branch is doing? Why don't you make these laws?" Well, the answer is there's not a lot of laws being made, and so they are in that. And I have a lot of thoughts about maybe why that is and why it shouldn't be, but maybe we'll get into that later.
Well, as you alluded to, Bill, with this question about sort of federal agencies having their power reined in, I want to dive into the Chevron case and then still talk about some of the themes we're talking about in terms of, because again, to me, it seems like the overall term, and as you said, Kelsey, the last few years are almost sort of an implicit but very important civics lesson for all of us, that if the legislative branch, Congress, does not do what it's supposed to do, then the executive branch, the president and his administration, will sort of step in to fill the void, and then they'll get sort of swatted down by the Supreme Court if the Supreme Court is doing what it's supposed to do. And so there's a lot of deep issues in there that maybe scream out for some reform and resolution at the federal level. But there are a lot of folks who are pointing to the Chevron case as an example of that, saying this is a really important step in the right direction to help to restore or re-bolster the constitutional order and the separation of powers. And Kelsey, I want to get your sense of that case, help our listeners understand it. And I want to read an excerpt from an article that you just recently wrote and posted for Deseret News. We'll, of course, include that article in the show notes as well. But to help our listeners understand the Chevron case in particular, you write, Kelsey, in your Deseret News piece, the precedent called the Chevron doctrine instructed judges across the country to defer to federal agencies' interpretation of the laws passed by Congress, even when the agency's rules had no clear basis in the written text. Friday's ruling puts the onus on Congress to pass clearer, more specific policies and gives individual Americans, as well as companies or religious organizations, more power to challenge the federal rules they take issue with. Kelsey, I don't think I've seen a description that's that tight and concise and clear as to what Chevron is. And so I want to ask you, reading that at first blush, that all sounds like a good thing to me. We're basically forcing Congress to say, do your job. But I want to ask, what are you hearing as you've covered this issue and as you've written about Chevron in particular? What's the reaction to it based on what you're seeing through your reporting?
What's tricky about this situation is that if everything in government was functioning as it's meant to be functioning, I believe, as maybe the founders would hope it was functioning, I'm not sure we would end up where we are with the Supreme Court's ruling on the Chevron doctrine, because I don't think you would be saying, oh, what are these federal agencies up to? Like, where do they come up with this idea? Because they would have clear guidance from leaders in Congress about what exactly a policy is how it's meant to be put in place. So the only thing I feel bad about in my description is if it makes it sound as if obviously federal officials are up to no good or federal agencies were purposely trying to get away with something. In reality, I feel like most federal officials are trying to work with the text they have and make common sense policies that fulfill the goal of the written text. But often the written text will just say, we want this to happen. We want there to be more protected farmland. We want there to be religious freedom protections in healthcare. We want there to be cleaner air. And it doesn't say, like, what fines are you allowed to put in place to make that happen? What birth control should be covered by employee health plans. And so it's up to these federal agencies to try to figure out, okay, this would make sense under this guideline and this wouldn't make sense. And the Supreme Court said in the new ruling that for the past 40 years where Chevron doctrine was in place, things have just spiraled out of control a bit, where when a federal agency appears to do something inappropriate, there was just almost no option to rein them in. Because if you were an individual, the people who brought the case this term were fishermen, you had very little power to force a change to a rule that you felt was unfair. And so now moving forward, it'll be a more balanced power dynamic heading into legal cases. But of course, it's also sort of a warning signal to Congress that says, if you don't want to see federal agencies in court time and time and time again, you need to pass more directive policies that say, here is the policy outcome we're hoping for, and here is exactly what we want the agency to be doing to ensure that that policy outcome happens. The interesting question from the ruling, and I think what more liberal folks are frustrated about, is this allows judges to ask more questions of federal agencies, and are judges always in the best position to do that? They're not experts on all of these issues, on the environment, on healthcare, on religious freedom. And so it's possible that instead of putting the ball in Congress's court to write more specific policies, it'll actually just have judges running a bit wild and overturning rules that they just happen to not agree with, perhaps for ideological reasons, political reasons. And that's the concern, is that you've given judges across the land authority that they might abuse in the same way that federal officials had been accused of abusing power.
Kelsey, would a solution be, and then Bill, I'd love your take on this as well, but would a solution, again, come back to if Congress could write laws that were clear and specific enough that essentially the latitude that a judge has to interpret something in a given way would be limited? Isn't that right?
Absolutely. If a law was pretty specific, the judge is just plain interpreter and saying, okay, the law said that we wanted to give each farmer 5 apples. Does the federal agency's instructions say give each farmer 5 apples? So that is the goal that I think everyone is meant to be working towards now. But many people who are looking at this case are just skeptical, saying, I just don't think that that's the way Congress is going to operate, at least in the short term.
So Bill, to Kelsey's point of whether Congress will, or maybe even whether they can, because one of the arguments that's been brought up during this discussion is the fact that a lot of these issues are just very, very complex. And folks who work in the policy space, who spend lives doing it, will tell you, I mean, here at Sutherland, that we work in the space, and I will tell you, in the time that I've been doing this, that these are lots of tough issues, they're very complex. But does that sort of speak to almost the background of Chevron, how it got started?
Yeah, definitely. And you'll pick this up, I think, in the dissenting opinion in the case today. 3 of the justices, and they focused a lot, and they raised some specific issues. Why should we think that federal judges will know about particulates in the air, or very, very specific kinds of things? And so the strong argument against this ruling, or in favor of deferring to the administrative agencies, is that they theoretically will be composed of subject matter experts. You kind of imagine scientists or something, and they're sitting around and they know all these details, and they can handle that, and that Congress can justifiably think, hey, they'll handle these things that we can't understand. The challenge, of course, and the reason that I think the court ruled the way it did, is that's really an extra constitutional consideration, because the Constitution itself specifically says that the legislative branch is the one to make the laws. And to the degree it looks like executive agencies are adding kind of making rules that bind the subjects to the U.S. Constitution, what they do appears to be making law. I would argue is. And so that's created, that makes administrative law, the field of sort of how do you deal with government regulations by executive branches, particularly challenging. So the Supreme Court, when they issued the decision in Chevron in the 1980s, they were trying to deal with that. What I think, and again, this is in the majority opinion, I think it's kind of well described. For much of the history of the United States, executive agencies were largely only issuing rulings that affected how the agency's personnel work themselves, not so much how citizens are affected. But the beginning with the New Deal in the 1930s, the agency's roles became much more significant, and more regulations are being applied. How do the courts deal with that when these issues may be really technical or specific? And the majority opinion says, well, in the 1980s, the thought was, well, why don't we just let these? We'll assume that the agencies are going to act very consistent with what Congress intended. In other words, if Congress passes a law, the agencies act quickly to implement the law through some specific regulations, we can assume those regulations are probably a fair approximation of what Congress would have done. But over time, many people, including the author of the opinion in the Chevron deference case, just started to feel like, well, no, actually, this is, I think Kelsey correctly said, feel like maybe this is spiraling out of control. And some of the examples, these are more in the concurring opinions, but where you see a particular regulation changing every couple of years. Every time there's a new administration, there's new rules on Title IX, there's new rules on air pollution. And so the feeling of well, gosh, these are let the experts speak doesn't appear to be what's at work there. It's rather maybe more the president's ability to kind of affect policy by encouraging the agencies to adopt new rules. So I think those kinds of considerations are exactly what led the court to rethink this, to accept a question, and to do something that's not common, but it does happen, and that is to overturn a previous ruling and to say, well, that we've tried that ruling, but it's more consistent with the Constitution if we now step back and say that the courts, they do have a role. They can't figure out all of the specific issues that experts are intended to address. But they can see whether or not there's a good fit between what the experts do and the language that Congress has passed. And if they do that, then we know that the courts are doing what they should be doing in this balance between all of the different branches of government.
Bill, I want to ask a process question, and really for either of you, and then we want to take a quick break and then come back and kind of dive in more to just the Supreme Court at the level of how we talk about it as a public. Because as you've written about and spoken about articulately many times, it seems deeply flawed the way we view the court. So I want to get into that after the break. But first, kind of this process question of, because both of you alluded to it, this idea of, well, I think, Kelsey, if you said that if Congress passes a law saying we shall have clean water and clear air and, religious freedom and a strong economy or something like that. And then they're essentially saying, hey, agencies, go figure out how to do all that. We want all these good things. Agencies fill in the fine print. My question is, if I'm a federal agency, and I think that this case, the issue that brought this case to bear, as you mentioned, Kelsey, was with a group of fishermen, and Bill, you've talked about this previously as well. But if there are fines or costs involved, like whatever the issue is, if Congress delegates to a federal agency authority to determine what kinds of fines to impose, say on polluters or anything like that, and also for the federal agencies to determine the level of those fines, does the federal agency then have to come back to a congressional committee and say, hey, here's what we came up with. We think we should charge $100 per infraction based on this fee schedule for this level of severity? And then does Congress have to sort of say, yes, that makes sense, go forth and do? Or can the agencies just sort of, once they have that kind of delegated authority from Congress, can they just go and kind of do whatever they want until there's a challenge, like there has been in this case in particular? Maybe Bill, start with you, and then Kelsey, if we missed anything.
It's a great question. The answer is no. They don't have to go back and ask. And part of the reason for that is that Congress enacted a law many years ago, the Administrative Procedure Act, that describes how how the executive agencies can go about enacting these rules, and they don't include that. Now, you do that does raise an interesting point, because some states do that. And this is, I think states and the ability of states and federalism is probably kind of a hidden beneficiary of this decision. But some states do have oversight committees where they look at and can overturn a regulation they feel is at odds with the initial legislation that they pass, which I think is very positive. And I think something similar will happen, although in a kind of because there's no specific oversight mechanism other than for Congress to come back and say, well, that you've interpreted the law wrong, and now we're going to amend the law to be more specific. But the states, I think, will often be the ones pushing back. They're the ones who are often highly regulated. They're ones who have to implement. They get a directive from a federal agency to do this thing or that thing, and they'll have to carry that out often, and it will reflect their ability to do their work. So I think states will be asking the courts to review agency rules and regulations, terminations to make sure that they are consistent with what Congress has done. Because if Congress is acting appropriately within its power under the Constitution, the states are going to be bound by that. But if the agencies or Congress act outside of their authority, then the states really need to push back and preserve their own ability to make decisions in the areas that are the majority of areas that are delegated, not delegated, but that they have retained to themselves to decide.
And Bill, that's actually what prompted my question. In some of my past work over the years, I worked for a state agency, and I was on the legislative affairs team and spent a lot of time with legislative committees, whether it's appropriations committees or standing committees, and I just remember there being a pretty high level of back and forth between the legislature through given committees and a given agency about what they were doing, and that's what I was wondering if it's not happening at the federal level. Again, to your point, maybe that's something that we can learn from the states to pass back to the federal. And Kelsey, from your perspective, as you've kind of looked at this issue with the national lens, is there kind of this difference between it? Do these things just function differently at the federal level compared to the state level? Like, are we onto something that maybe there's enough of what states are doing that is different and more efficient and effective in this regard? Give us a sense of are things just different in Congress with how they govern federal agencies compared to what we do at the state level with state agencies?
Well, the main thing I wanted to highlight is that what you were describing in your question would seem to many like a nightmare scenario where you get this law, the federal agency needs to work on deciding how to apply the law. Okay, now let's have another committee meeting about it. No, we're not happy. Let's have another committee. So that would be very difficult and slow moving. And so what I return to is something that comes up in many Supreme Court cases, which is, does this policy generally fit the pattern of other similar policies? So it's like this question of, do you feel like you've mimicked types of rules that we've seen in other contexts? And that's in like the religious freedom cases I've followed. Are you able to say that I've put in writing the types of religious freedom protections that we have also seen in writing in other contexts? Because you could basically copy and paste similar language. And so I think that you can have that to a certain extent in the federal rulemaking process moving forward, where if Congress uses certain terms in different types of policies about fines, then you would know that there's some sort of universal fine schedule that seems appropriate so that the conversation doesn't start from scratch every single time.
That's a helpful clarification. And I think, again, it leads to this idea of, it seems clear to me that we need some reform and improvements to how these things work on the federal level. We can always improve on the state level as well. I'm not suggesting that, but just this, that hopefully, and maybe this case, among many others, will sort of, again, help bring that encouragement that there is some recentering needed for all three branches at the federal level. But in this case, in particular, for Congress and the executive to make sure they're doing what we need them to do, as Kelsey, as you alluded to before, that people who are concerned that Congress maybe just won't do that or not anytime soon, maybe that's something that all of us as voters need to keep in mind, that we want Congress to take its role, its constitutional role more seriously, to pass laws, to pass good, clear, specific laws, so that hopefully we can prevent some of these conflicts in the future that would need to go to a court level. Well, let's take a quick break because I want to come back and then again get into some of the general view of how we discuss and debate these kinds of issues publicly, because I think there's some opportunity for improvement, and then finish off with what's next. The Chevron doctrine in particular, what does it mean for Congress moving forward? What do you both predict or anticipate? And then what does it mean for federal agencies? And maybe is it going to have any kind of effect on the political and policy debates we all have that are continuing to move forward in the public dialogue? So let's take a quick break. We're going to come right back and get more on this issue with Kelsey Dallas from Deseret News and Sutherland's Bill Duncan. This is Defending Ideas. We'll be right back.
Sutherland Institute is an independent, nonprofit public policy think tank based in Salt Lake City, Utah. Our mission is to defend the principles of the American founding and strengthen the institutions of civil society essential for those principles to endure. Sutherland provides research, events, and multimedia to policymakers and the public to promote the principles of faith, family, freedom, opportunity, and responsibility. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. I'm Nic Dunn. We're going to continue our conversation with Kelsey Dallas from Deseret News and Bill Duncan here with us at Sutherland about the issue of Chevron deference and the U.S. Supreme Court decision that overturned that legal doctrine. But first, I want to remind you, if you like what you're hearing today, please visit defendingideas.org. You can access this and previous conversations and also get access to short clips on our YouTube channel that you can use in your conversations with friends and family about these issues and that you can share on your own social channels as well. You can also subscribe to Defending Ideas on any of the major podcast platforms, wherever you like to get your shows, whether it's Spotify, Apple. Just go to your favorite provider and plug in Defending Ideas in the search bar and click that subscribe button. And if you're watching on YouTube, on the Sutherland Institute YouTube channel, make sure you subscribe to the channel and click the little bell icon in the corner so you get notified each time a new episode of Defending Ideas becomes available, which is every Tuesday morning. All that and more at defendingideas.org. Kelsey and Bill, I want to kind of continue and maybe put a bow on this conversation, I guess, and elevate it a little bit, that it seems to me that the way we discuss, we meaning the public, the way we discuss the Supreme Court is deeply flawed. Bill, you've written about this often and spoken about this, that if we as Americans view the Supreme Court as a mini Congress that is designed to just dole out policy wins that we like, of course we're going to be disappointed. And also, of course, we're doing it wrong when it comes to our civic responsibilities, voters, to sort of the role of the Supreme Court as an institution, and also how that affects these other issues that, again, I mentioned earlier, this idea of we need to recenter how we as voters view each of these three branches of government at the federal level. And I give all that kind of color commentary, Kelsey, to maybe lead into a question for you, that as you've covered the as you've covered the Supreme Court more broadly on the variety of issues that you've written about and reported about, how would you describe sort of the way the public discourse shapes around the court and the decisions that happen, and maybe in particular about this Chevron case? How are people viewing the court with respect to, again, its role in the Constitution? Anything interesting that you're seeing in your reporting?
I'll talk specifically about the Chevron decision first, because my headline on my story about that decision was something like the Supreme Court sides with conservatives in major case over federal power. I stand by the headline in the sense that leading into this term, it was many more conservative lawmakers that were really excited about the possibility of overturning the Chevron doctrine. However, I didn't need to put that conservative versus liberal spin on it, because in the long run, you might be surprised, we all might be surprised that maybe everybody is happier with the outcome, because we have a better way to resolve situations where a federal rule just doesn't seem to make sense. Can we revisit it? I, as an individual, can force that revisiting. So I want to say that I am not immune to this language of conservative versus liberal, the court's conservatives majority versus its three liberal justices. It matters quite a bit in opportunities like the chance to overturn Roe v. Wade in 2022. That was made possible by the way that appointments shook out, where former President Donald Trump ended up being able to appoint three. But I am reminded again and again, just by following Supreme Court decision days, that the Supreme Court is full of surprises. Individual justices are full of surprises. The appointees from Trump end up in minorities with the liberals, end up in majorities with the liberals, plus maybe Chief Justice John Roberts. So it's not good to just say, oh, it's 6-3, 6-3, 6-3, because there are always surprise rulings that cut across ideological differences.
Bill, what would you add to that? I mean, it's a really interesting point that Kelsey brings up, that obviously these things happen and the court functions not in a vacuum, but in the context of our partisan politics as a nation, in the context of our political and ideological discussions and disagreements that we have. So all of that stuff has an impact, takes a role. But how would you then characterize the discussion in the public around the Supreme Court, given what Kelsey just said?
Well, I agreed with Kelsey's comment. I think that's right. Even today, as an example, as we're recording this, the court issued an opinion related to January 6th and some of the charges made against. Well, the majority opinion included Justice Jackson, who was appointed by President Biden, and the dissent included Justice Barrett, who was appointed by President Trump. So I think that the partisanship doesn't really map well onto the role of the Supreme Court. The Supreme Court's role is interpreting basically written constitutional and statutory provisions. They're there to ensure that the language is carried out, as it was intended, either initially by the people represented by the framers in the Constitution, or by Congress when they pass statutes, or in some other in other cases, others who create laws. And if we always think in terms of policy, but how does this affect abortion rights or religious freedom or whatever? I think we're missing something really important about what the Supreme Court is supposed to do. Sometimes in trying to I think faithfully discharge the obligation they have under the Constitution, they'll come up with decisions that have the effect, like Kelsey was describing, of doing things that we think are really great or we really like. Sometimes they'll come to conclusions that we don't like. It's not the Supreme Court's role, though, to sort of satisfy us by making policies that Congress or the Constitution don't allow for. That would be a betrayal of their position. And if we ever felt, and occasionally we do sense that maybe the justices are responding to political pressures or outside kinds of pressures outside of their specific role, then we're really at risk, because they're the only branch that's intended. The other branches are given a little bit of leeway to push a little bit. In some ways, I think maybe this analogy, you often hear the umpire analogy, that the court's just supposed to look at the law and call balls and strikes. And I mean, particularly in these administrative agency cases, I think the courts may be better understood as sort of playing a traffic control role of making sure each branch is in its lane, including their own, and making sure the states are allowed to kind of go down their lane without interference. And maybe Congress is a little congested right now, and so they're not moving the way that they should. But that doesn't mean we waive the rules and allow courts to, or expect courts to solve problems that Congress is not solving on its own. And but as long as they're kind of keeping everyone in their own lanes and allowing the executive, the legislative, obviously the judicial, but also the states to play the roles that they're assigned by the Constitution, then the court is being successful, even if we don't always like the answers they come up with in a particular case.
Kelsey, as we wrap up, the last question I want to ask is really just what's next? I mean, with the Chevron decision, what does this mean moving forward for Congress? Bill, as you mentioned, for states as well. Does this give an opportunity for states to take a more elevated role on some of these issues? But for Congress, federal agencies, state elected leaders, and maybe impact on just our political and policy debates in general, what should we be looking for in the horizon for what's next after the Chevron ruling?
Unfortunately, I think in the short term, there will be a flurry of lawsuits because people are going to say, okay, the Chevron doctrine's not in place anymore. And so this is my opportunity to challenge a rule that I've been frustrated by. I just say unfortunately because the legal system moves quite slowly. And so there could be important questions raised that are not answered for many years. So perhaps a brighter version of that scenario is that you could go straight to the federal agency, or Congress could realize that there's going to be a problem and say, let's get to work on this right away and try to problem solve. But there's definitely going to be conversations about checking past rules and saying, is this really appropriate? Do we feel like there's a basis for it in the text? And there's also a word of caution for Congress now moving forward that when they pass new policies, they have to be a little bit more specific to ensure that the policy isn't ultimately ripped apart or put on hold in courts because of whatever the federal agencies do with it.
Bill, if you've got 30 seconds in an elevator with an average voter and they say, hey, Bill, I saw the headline. I read Kelsey's article about the Chevron thing. Was that a good decision? What do you tell them? Did the court get it right by overturning Chevron? And if so, What's next?
I think the court got it right. I would tell them, read Kelsey's article to understand it better, but I would say the court got it right. And I think the positive spin on this is that it does give an opportunity for the states to show, hey, we can handle a lot of these issues. It gives the opportunity for Congress to do better. So in a lot of ways, even though it will take time and there'll be some bumps probably, I think it could end up being quite good.
Well, Bill, I want to thank you always being a regular on the show, lending your time and expertise. And Kelsey, I want to thank you as well for joining us and talking about your reporting for Deseret News. We'll encourage people to go read your work there and just really appreciate your time with us on Defending Ideas. Well, we're going to take a final break before we leave you with some talking points. This is Defending Ideas. We'll be right back.
Sometimes it's hard to keep up with the latest policy debate that affects your life. The solution? Subscribe to Sutherland Institute's weekly newsletter, where you'll find in-depth insights from seasoned policy experts, compelling multimedia, and advance notice of special events. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. I'm Nic Dunn, and wanted to thank you for being with us and just share some thoughts that I had before we close out this episode, because the conversation with Kelsey Dallas from Deseret News and Bill Duncan here at Sutherland, I think gave some really important takeaways for each of us that we should use in our conversations if we get into any debate or discussion about this particular ruling or any rulings that the U.S. Supreme Court issues on various topics that might hit the news. And there's three key things that I capture that I think we can use in our discussions. And those are the following. Number one, let's remember that lawmaking authority is vested in Congress, not in federal executive agencies. And so when agencies, if they're engaging in creating their own rules that have the force of law without congressional action, that can actually be really problematic and kind of run counter to this idea of separation of powers that, again, vests Congress with lawmaking authority. The second point is that this ruling really should prompt Congress to take its role governing more seriously, which means they need to write laws that are more specific and more clear and well-crafted to fixing a particular problem that they're trying to address, which means each of us as voters, we need to expect that of our members of Congress and of Congress as a whole. We want them to engage in responsible, clear, limited governance to solve the problems that we face as a country, and this ruling should help encourage and foster that, especially if we expect that ourselves when we go to vote for our congressional representatives. And number three, let's remember that the role of the Supreme Court is to protect the constitutional order, which means protecting the separation of powers. It is not to hand down policy wins that you or I might like. We shouldn't view the Supreme Court as sort of a mini Congress that we just want wins from on the issues we care about. We should always view the court as enforcing its role, protecting the separation of powers, protecting the constitutional order. In this case, on the Chevron decision, it did its job well, as we heard from the discussion today. Well, that is it for this episode. I hope you have enjoyed this discussion on Defending Ideas, and that you feel better equipped to go out and discuss and defend some of the principles we talked about today. Please subscribe to Defending Ideas on any of the major platforms wherever you listen, Apple, Spotify. Just go to your favorite place to listen to shows, search for Defending Ideas and click subscribe. And also you can subscribe to the Sutherland Institute YouTube channel. And if you do, click the little bell icon in the corner so you get notified each time a new episode drops. You can get access to all of this and more at defendingideas.org. And lastly, if you want to support the broad work of Sutherland Institute, in particular, if you want more conversations like this to happen, please support our work and visit sutherlandinstitute.org/donate. That will do it for this episode of Defending Ideas from the Sutherland Institute in Salt Lake City. I'm Nic Dunn. We'll see you next time.